Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss Section 39 to 45 of the Bharatiya Sakshya Adhiniyam.
Today, we're diving into a really important topic, Section 39 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section deals with opinions of experts, and trust me, it's a must-know for anyone gearing up for judiciary and APO exams. So, let's get right into it.
So here's our game plan for today. First, we'll introduce what Section 39 is all about. Then we'll break down its key components. After that, we'll see how it actually works in court with some examples and important cases. We'll also quickly compare it to the old law. And finally, wrap up with a quick revision tailor-made for your exams.
All right, let's start with the basics. You know, when a court is trying to decide a case, it sometimes runs into issues that are, well, really technical. Think about things like complex science or digital forensics. A judge can't be an expert in everything, right? That's exactly where the section comes in, providing a way for the court to get help.
Now here's the core text from the Bear Act. So what does this actually mean in simple terms? It's pretty straightforward. Whenever a court needs to figure something out related to foreign law, science, art, or any field that needs special skills, the opinions of people who are specially skilled in that area become relevant facts. Basically, the court can listen to these experts.
And what kind of fields are we talking about here? Well, the scope is pretty wide. It covers the traditional areas you might expect, like foreign law, science, art, handwriting analysis, and finger impressions. But what's really important about the new law is that it specifically includes electronic evidence, which, as you know, is a huge part of modern cases.
Okay, moving on. To really master any legal section, you've got to break it down into its essential elements, or as I like to call them, its key ingredients. So let's do that for Section 39. Let's look at a few key terms here. First, specially skilled. This just means someone who has special knowledge, either from studying or from practical experience. That person is called an expert. Now, when that expert gives their opinion, it becomes a relevant fact, meaning it's a piece of evidence the court can consider. And finally, the examiner of electronic evidence is the specific expert for all things digital, as defined under the IT Act. So for this section to apply, the court kind of follows a logical sequence. First, the court has to actually need help with a technical point. Second, the issue itself must require some specialized knowledge, like medicine or forensics. Third, the person giving the opinion has to be genuinely qualified. If all these boxes are checked, then fourth, their opinion becomes a relevant fact in the case. Simple, right?
All right, so that's the theory. But how does this all play out in a real courtroom? Let's get practical and look at an example and some major court judgments to see this section in action.
Let's take a classic hypothetical situation. Imagine the court is trying to figure out if a person, let's call him A, died from poisoning. Well, how would a judge know what symptoms a specific poison causes? They wouldn't. So the opinions of medical experts on those symptoms become super relevant. This is a perfect example of how an expert helps the court connect the dots. Now, what about the value of this expert opinion? The Supreme Court and various high courts have had a lot to say about this over the years. Let's touch upon some of the most important cases you need to know. First up, the landmark case of State of HP versus Jai Law. The key principle from this case is that expert evidence is advisory in nature. It's there to assist the court, to guide it, but it never ever dictates the final decision. The judge is not bound to agree with the expert. The courts have also urged a lot of caution, especially with handwriting experts. In Murari Law, the court said that these opinions need to be looked at very carefully. Then in Magan Bihari Law, it was held that you can't convict someone based only on a handwriting expert's opinion. That's just not safe. And finally, Ram Narayan Singh established a golden rule. Expert evidence needs support from other, independent, corroborating evidence. You know, this whole idea is captured perfectly in a Latin legal maxim. Judex est judex peritus peritorum. It means the judge is the expert of experts. It's a powerful reminder that no matter how skilled a witness is, the ultimate expert in the courtroom, the one making the final call, is always the judge. Okay, so let's put this new law into context. How does it stack up against the old Indian Evidence Act? And we'll also tackle a question that I know many of you have about this section. So this provision isn't entirely new. It used to be Section 45 of the Indian Evidence Act of 1872. Now it's Section 39 of the BSA. The core idea is the same, but the biggest update, as we mentioned, is that the new law explicitly brings electronic evidence and its examiners into the fold, which is a much-needed modernization.
And this leads us to that common question I was talking about. What is the punishment that's prescribed under Section 39?
Well, the answer is there is no punishment. And it's so important to understand why. Section 39 is a rule of procedure. It's all about whether a piece of evidence, the expert's opinion, is admissible in court. It doesn't define a crime, and because it doesn't define a crime, there's no punishment attached to it. That's a key point for your exams.
And that brings us to our final and perhaps most crucial segment, the exam quick revision. Let's boil everything down to the absolute essentials you need to remember for your exams.
For your prelims, you can definitely expect a direct question, something like the section number or what it deals with. For mains, be ready for a short note on the evidentiary value of expert opinion. That's a favorite. You might also get a problem-based question where they give you a fact scenario and ask you to apply this section.
So, for a last-minute revision, just remember these key points. 1. It's Section 39 of the BSA. 2. Its main job is to help the court with technical stuff. 3. Its evidentiary value is only advisory, not conclusive, and it usually needs corroboration. And 4. It's a very, very important section for both your prelims and mains. And that wraps up our detailed analysis of Section 39. It's a fundamental part of the law of evidence that balances expertise with judicial discretion. For more such legal explainers focused on your judiciary, APO, and other law exams, please stay connected with us here at Ganga Education.
Today, we're diving into a really interesting section, Section 40 of the Bharatiya Sakshya Adhiniyam 2023. Now, this one is all about how courts handle expert opinions. For anyone preparing for the judiciary or APO exams, this is an absolutely crucial topic, so let's get right into it.
So, here's our plan for this session. We'll start with the basics to build a strong foundation. Then, we'll break down the actual legal text. After that, we'll look at some practical examples, connect it to broader legal principles, and finally, wrap up with the key takeaways you'll need for your exams.
All right, let's start with the fundamentals. You see, in court, you often have experts, doctors, forensic scientists, handwriting specialists, who come in to give their professional opinion. But here's the thing, a court can't just take their word for it. There has to be a way to test if that opinion is actually accurate and reliable. And that, right there, is the core purpose of Section 40.
To put it simply, Section 40 is all about checking credibility. It allows certain facts, which might seem totally unrelated to the case at first, to be brought into evidence. Why? Because these facts either back up what the expert is saying or they completely contradict it. This gives the court the power to decide, okay, how much should we really trust this expert's testimony?
Okay, let's move on and deconstruct the legal text itself. For any law exam, knowing the precise language of the Bear Act is a game changer. So we're going to analyze the exact wording of Section 40, piece by piece.
So here it is, the official language of this section. Take a close look. There are 3 phrases here that are doing all the heavy lifting: not otherwise relevant, support, and inconsistent with. Honestly, if you understand these 3 ideas, you've understood the entire section. Let's break them down.
Now, this is where it gets really clever. First, not otherwise relevant. This means we're talking about facts that on their own have nothing to do with the main issue of the case. They only become important because they help test the expert's opinion. Second, support. This is pretty straightforward. It means facts that strengthen or confirm the expert's conclusion. And third, inconsistent with. These are the facts that challenge or poke holes in what the expert has claimed.
So how does this play out in a real courtroom? Well, it's a very logical 3-step process. First, an expert gets up and presents their opinion. Second, the lawyers introduce other facts that either support or contradict that opinion. And finally, the judge takes all of this information and evaluates just how reliable that expert opinion really is. You see, it's a brilliant check and balance system built right into our evidence law.
Now that we have the theory down, let's see how Section 40 actually works in the real world. Because let's be honest, it's the practical examples and landmark cases that make these concepts truly stick. This is where the law comes to life.
This is a classic example taken straight from the Act. Imagine an expert testifies that the victim died from a very rare poison. Let's call it poison X. Now, what if another fact is introduced, that several other people who were confirmed to have ingested poison X all showed the exact same, very unique symptoms as the victim? Well, that fact supports the expert's opinion, right? So under Section 40, this fact, which was previously about totally different people, suddenly becomes relevant to this case. And this idea is perfectly captured in the case of State of HP versus Jai Law. Here, the Supreme Court laid down a really important principle. An expert's opinion can't just float in a vacuum. It has to be anchored by solid facts and circumstances. The expert can't just say something. They need a verifiable basis for their opinion for it to be considered reliable.
And in a similar vein, we have the case of Murari Lal versus the State of MP. The court here emphasized that an expert's opinion is just one piece of the puzzle. It should never be looked at in isolation. The judge has to look at the entire picture, all the surrounding evidence, and see how the expert's opinion fits in. It's all about taking a holistic approach.
All right, let's zoom out a little bit and place Section 40 in its wider legal context. Behind every section, there are fundamental principles working in the background. So let's connect this to a very powerful legal maxim and also see where this provision came from.
This Latin maxim, judex as judex peritus peritorum, perfectly sums up the spirit of Section 40. It means the judge is the ultimate expert of experts. And what does that tell us? It means that no matter how famous or qualified an expert is, at the end of the day, the judge is the final authority. The judge is the one who decides how much weight to give that expert's opinion. Now, this is super important for all you judiciary aspirants. The role we now find in Section 40 of the BSA was previously located in Section 46 of the old Indian Evidence Act of 1872. And please, make a note of this. There has been no substantive change. The wording, the principle, it's all the same. It's just been renumbered. This is a classic prelims question.
Okay, let's get to the most important part for you, the exam takeaways. We're going to distill everything we've talked about and focus on what you absolutely need to remember for your judiciary and APO exams.
So for your exam prep, here are 4 key tips. First, for prelims, you can definitely expect a direct question on what Section 40 is about. Second, for mains, be ready for a problem-based question where you have to decide if an expert's opinion is reliable. Third, always remember the old section number, Section 46 of the IEA. And fourth, if you want to make your mains answer stand out, quoting the maxim, judex is judex peritus peritorum, will show the examiner you have a deeper understanding.
And for a super quick revision, just burn these 4 points into your memory. The section is Section 40 of the BSA. The core idea is making facts relevant to support or contradict an expert. Its purpose is to test reliability, and the old law was Section 46 of the Indian Evidence Act. That's really the whole thing in a nutshell.
And that wraps up our detailed breakdown of Section 40. The biggest thing to remember is that while expert evidence is vital, it's never the final word. Section 40 gives the court the tools it needs to look closer, to question, and to ensure that justice is ultimately based on facts that are reliable and thoroughly tested. For more exam-focused content like this, stay connected with Ganga Education.
Today, we're going to dive deep into a very important piece of our new legal framework, and that is Section 41 of the Bharatiya Sakshya Adhiniyam 2023. आज हम डिस्कस करेंगे Section 41 of the Bharatiya Sakshya Adhiniyam. Now this section falls under the Relevancy of Facts chapter, and let me tell you, it deals with the super important topic of opinion on handwriting. For anyone preparing for judiciary and APO exams, this section is absolutely crucial, so let's break it down properly. So, here's our plan. We'll start with a quick introduction, then we'll decode the bare act to see what it really says. After that, we'll look at a real-world example, touch upon some key case laws, and compare the new law with the old one. And finally, we'll wrap it all up with a quick revision just for your exams. Let's get started. Okay, so first things first, what is Section 41 really all about? Well, to put it simply, this section becomes relevant whenever a court needs to figure out who actually wrote or signed a document. It's the legal tool that helps the court form an opinion on that very question. Now, check out this key line from the Bare Act. What does all this legal language actually mean? In simple words, it just means that when a court is trying to figure out whose handwriting or signature is on a document, the opinion of someone who is acquainted with that handwriting is considered a relevant fact. That means it can be brought in as evidence. To really get a grip on this, we need to break down the essential parts of the section. You know, like any law, Section 41 has some specific keywords that have very precise legal meanings. Understanding them is key. इस section में 3 important elements हैं. First, acquainted with handwriting. This isn't just about casually knowing someone's writing. The law has very specific ways you can become acquainted. Second, relevant fact. This is any fact that the court allows to help prove or disprove another point. And third, certifying authority, which you'll see is a really important modern addition for electronic signatures. So this begs the question, right? When does the law actually consider you to be acquainted? Well, there are three main ways. The first one is pretty obvious. You've actually seen the person write with your own eyes. The second way is that you've received documents from them, like letters back and forth. And the third is that you've handled documents written by that person as a regular part of your job, in the ordinary course of business. Okay, enough with the theory for a moment. Let's see how this section actually plays out in a practical, real-world situation. The illustration given in the BEAR Act itself is actually perfect for this. So let's take a situation. Imagine the court has a question before it. Is a certain letter in the handwriting of a person we'll call A, who is a merchant in Itanagar? This is the kind of business dispute that happens all the time. And here's where it gets interesting. So A is our merchant in Itanagar. B is another merchant in Bangalore who gets letters from A. C is B's clerk, and his job is to file all of A's letters. And D is B's broker, who has to read and advise on those letters. Now here's the kicker. B, C, and D might have never ever seen A physically write anything, but because they deal with his letters all the time as part of their business, the law says they are acquainted with his handwriting. And that means their opinions are relevant evidence in court. See how that works? Now, to really understand how a law is interpreted and used, you have to look at case law, right? So let's check out a key judgment that's related to this very section. The case you need to know here is Ram Narayan versus the state of UP. It's a landmark judgment that really gets into the nitty-gritty of admitting opinions on handwriting as evidence. So what did the court say? Well, in this important case, the court held that the opinion of someone who is familiar with another person's handwriting is, in fact, admissible and relevant evidence. This principle directly supports the entire foundation of what we now see in Section 41. It gives it that solid judicial backing. This whole idea is also captured beautifully by a legal maxim. Judge ex is judex peritus peritorum. It literally means the judge is the ultimate expert of experts. This is so important because it reminds us that even though we can bring in expert opinions or opinions from acquainted persons, the final call always rests with the judge. The court is never bound by these opinions. All right, let's shift gears to something that's super critical for your competitive exams, comparing the new Bharatiya Sakshya Adhiniyam with the old Indian Evidence Act. So, ये provision पहले Section 47 of the Indian Evidence Act 1872 में था. अब इसे replace किया गया है Section 41 of the Bharatiya Sakshya Adhiniyam 2023 के under. Now, while the basic idea of an acquainted person's opinion is still the same, here's the biggest change. The new law specifically and expressly includes the relevance of opinions on electronic signatures from a certifying authority. This is a huge update for our digital age. Okay, let's pull everything together from an exam point of view. This is the stuff you absolutely need to remember for your judiciary and APO exams. For your judiciary prelims, you can expect a direct question on the section number, something like opinion on handwriting is dealt with under which section of the BSA. And for the APO mains, be ready for a short note or even a problem-based question, probably based on that Itanagar merchant example we discussed. So, for a quick revision, just lock these three things in your mind. First, the section number, Section 41 of the BSA 2023. Second, the core concept. The opinion of a person acquainted with a handwriting is a relevant fact. And third, the key update. It now officially covers electronic signatures. Got it? And I'll leave you with a final question to think about. With this new inclusion of electronic evidence under Section 41, how do you think the role of the traditional handwriting expert is going to change in our increasingly digital world? Something to ponder on. For more judiciary, APO, and law exam-focused legal content, stay connected with Ganga Education.
Today, we're diving into a very important topic, Section 42 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is all about when opinions on a general custom or right become relevant in court. It's an absolutely crucial section for your judiciary and APO exams, so let's get right into it.
So here's our game plan for this explainer. We'll start by introducing the BEAR provision of Section 42. Then we'll break it down into its core ingredients. After that, we'll look at how it's actually applied in court with some case laws. We'll also touch upon its history, focus on some exam-specific tips, and finish up with a quick revision. Ready? Let's begin.
All right, first things first, we always have to start with the text of the law itself. Understanding the bare act is really the foundation for everything else that follows. So, what does this actually mean in simple terms? Well, it's saying that whenever a court is trying to figure out if a widespread custom or right actually exists, it can listen to the opinions of people who would know about it. Think about it. Customs are usually unwritten rules, right? So the law recognizes that the best evidence might just be the testimony of the people who have lived with that custom. Their opinion becomes a relevant piece of the puzzle.
Okay, so to really understand and apply Section 42, we need to break it down into its essential components, what lawyers like to call its ingredients. Let's see what they are.
The very first phrase to lock in is general custom or right. Now, the Act itself clarifies this for us. This is not about one person's private right. No, it applies to customs or rights that are common to a whole group of people, like an entire village community, or the specific traditions of a caste, or the practices of a particular trade group. It has to be general.
So think of it like a 4-part checklist, and all 4 conditions must be met for this section to apply. First, the court must be dealing with a question about a custom. Second, that custom has to be general, affecting a whole group. Third, the opinion has to come from people who are actually likely to know about it. We're talking village elders, community leaders, people with deep roots in the community. And finally, if these first 3 conditions are met, then, and only then, does their opinion become relevant evidence. It's a package deal. You need all 4.
Okay. Theory is great, but let's get practical. How does this actually work in a real courtroom? Let's walk through an example and look at some of the landmark judgments that have really shaped how this law is interpreted. Let's imagine a classic situation, the kind you might get as a problem question in your exam. A new landowner buys a big field and decides to block a path that villagers have been using for generations. The villagers are furious, and they go to court, claiming a customary right-of-way. So how does the court decide who's right?
This is exactly where Section 42 becomes the star of the show. So, Step 1, the dispute happens. Step 2, the court needs to form an opinion. Does this right-of-way actually exist as a custom? Step 3, to find out, the court calls witnesses, the village elders, people who've lived there their whole lives. And Step 4, their testimony, their opinion on the matter, becomes relevant evidence under Section 42. See, it's a pretty logical flow.
But, and this is a big but, not just any practice can be called a custom in the eyes of the law. The courts have set some very strict rules. This brings us to the landmark case of Thakur Gokul Chand versus Parveen Kumari. Here, the court laid down a critical test. It said for a custom to be legally valid, it must be ancient, it must be certain and not vague, and it absolutely must be reasonable. And building on that foundation, other important cases have added more clarity. In the Collector of Madura case, the court said the proof for a custom must be clear and convincing. It can't be based on flimsy evidence. Then in Ujagar Singh v. Jio, the court confirmed that a practice that has been going on for a very long time and is accepted by the community can definitely establish a valid custom. These cases are gold for your mains answers. Now, let's zoom out a little bit. What's the legal philosophy behind this section, and how does it compare with the old law that it replaced?
The spirit of Section 42 is captured perfectly by these 2 old legal maxims. The first one, consuetudo est altera lex, literally means custom is another law. It shows that the legal system respects traditions that have stood the test of time. The second one, communis ero facit jus, suggests that a common practice can eventually become law. Together, they really explain why the opinions of the community are valued so highly in these cases.
Okay, this next point is extremely important for your exams, so please pay close attention. What is the difference between this new law and the old Indian Evidence Act on this topic? The answer is simple. There is no substantive change. None. This provision used to be in Section 48 of the Indian Evidence Act of 1872. Now it's just been renumbered as Section 42 of the BSA. Just to make this crystal clear, take a look at the table. The old law was Section 48. The new law is Section 42. Has the meaning or the substance changed? Absolutely not. The core evidentiary principle is identical. The only thing that's different is the section number. Remember this. It's a classic prelims question. All right, let's get down to brass tacks. How should you prepare this section specifically for your judiciary and APO exams? Let's talk strategy. For your prelims, you can expect very direct questions. They might ask, Section 42 of BSA corresponds to which section of the old Indian Evidence Act?
The answer, as we know, is Section 48. Or they might ask, what kind of right is covered, general or private? The answer is, of course, general. For your mains, you might get a short note asking you to explain the ingredients of Section 42 with an example. You could also get a problem-based question, just like our right-of-way scenario. And please, always remember to cite the principle from the Thakur-Gokultend case. It adds so much weight to your answer.
We've covered a lot of ground, so before we finish, let's do a super quick revision to make sure the most important takeaways are fresh in your mind. So, for a quick recap, remember these three things. First, the section number. It's Section 42 of the BSA 2023. Second, the core concept. The opinion of knowledgeable people about a general custom is considered relevant evidence. And third, its exam importance. It is very, very high for both your prelims and your mains.
And that's a wrap on our detailed explainer of Section 42. It's a fascinating provision that shows how our formal legal system respects and incorporates the unwritten laws of society. For more judiciary, APO, and law exam focused content like this, make sure you stay connected with us here at Ganga Education.
Have you ever stopped to think about how a court is supposed to make a fair decision about a tradition that's not written down in any law book? Well, today we are diving deep into Section 43 of India's new Evidence Act. It's this really fascinating piece of law that connects ancient customs to our modern legal system. I mean, this is a huge challenge for any legal system, right? Just think about it for a second. A judge can't possibly be an expert on the unique practices of every single community. So how on earth do they make a fair call when a case comes down to a tradition that nobody ever wrote down? That's the exact puzzle we're going to unpack today. So here's our game plan. We'll start with that big cultural question. Then I'll introduce you to Section 43 as the solution. We're going to break down exactly how it works, see it in action with some real-world cases, do a quick comparison with the old law, and then wrap it all up with why this matters so much. Okay, first up, let's really dig into that core problem. Why courts sometimes need help that you just can't find in a law library. You know, a lot of legal battles aren't just about what's written in black and white in a contract. They get tangled up in these deep-rooted customs, very specific family traditions, or even what a single word means to people in a particular local area. And that kind of nuance requires a special insight that a judge, no matter how smart, might not have.
And this is exactly where the legal system brings in a special tool for the job, Section 43 of the Bharatiya Sakshya Adhiniyam, or BSA.
So, to put it simply, this section is like a bridge. It allows the court to bring in a kind of cultural translator, an expert witness who has this special insider knowledge about a certain custom or tradition. Their opinion then gets treated as relevant evidence, which helps the court really get the full picture. And this little snippet from the law itself, it really nails it. The key phrases to zero in on are special means of knowledge and relevant facts. This tells us it's not just any old opinion that gets heard. It has to be an informed opinion from someone with real expertise. And that's what elevates their testimony to the level of actual hard evidence. So, what does it take for an opinion to actually count under Section 43? Let's break down the core ingredients. The whole process is actually pretty logical. It all starts when the court itself realizes, hey, we need some help understanding this custom. Then, the issue has to be about something specific, like family principles or tenets, or the rules of a religious group. After that, you bring in the expert witness. Think of a community elder or a religious scholar. And finally, their expert opinion is officially accepted as a relevant fact that can help the court make its decision. Theory is great, but how does this actually work in the real world? Let's take a look at how this principle has been used in court and some of the big ideas that back it up. This section gets used in all sorts of situations. For example, if there's a dispute over the rules of a temple, the court might hear from a priest. Or in a family inheritance case that depends on tradition, a family elder's testimony could be absolutely crucial. It even comes down to things like understanding local slang used in a written document. And look, this whole concept, it's not some brand new idea. The legal system has recognized the power of tradition for centuries, and it's summed up perfectly in this old Latin maxim. Custom is another law. That's a really powerful idea when you think about it, that a practice followed by a community for a long, long time can basically become its own kind of law. Section 43 is the modern legal tool that lets a court formally recognize and interpret these unwritten rules. And we can see this principle working in some really important legal cases. A landmark example is the case of Setal Das versus Sant Ram. This case was all about the internal rules of a religious institution. The court basically said that testimony from people who were deeply familiar with that institution's practices wasn't just helpful, it was relevant evidence for figuring out how it should be run and who should be in charge.
Now, another vital case that really helps set the standard for this kind of evidence is Thakur Gokul versus Parvin Kumari. This ruling added a really important layer, almost like a quality control check. It established that you can't just claim a custom exists. You have to prove it with reliable evidence, and the expert witness has to show that they are genuinely knowledgeable. This makes sure the court gets credible, authentic information.
Now, for those of you who know the old Indian Evidence Act from 1872, you might be wondering, what's really changed with this new law? Let's do a quick side-by-side comparison. When you put them next to each other, you see this amazing continuity. The old law had this provision under Section 49. The new law puts it under Section 43. But the core function, recognizing expert opinions on customs and religious institutions, it's exactly the same. So the key takeaway here is simple. There has been no major change to the legal principle itself. The core idea has been carried over completely. The only real difference is the section number, which is so important for maintaining legal continuity. Okay, let's bring this all together. What's the big picture significance of Section 43? Why does it matter so much? At the end of the day, Section 43 is so much more than just a procedural rule. It's that vital bridge we talked about, connecting the formal, written world of law with the lived, unwritten world of culture. It ensures our legal system isn't rigid or blind to context, but can actually adapt to deliver justice that's fair, informed, and truly respects social realities. And that leaves us with one final thought to chew on. In a world that's getting more modern and globalized by the day, how important is the role of local custom and law? How do we find that right balance between universal legal principles and the incredible diversity of human tradition? It's a tough question, and it's one that provisions like Section 43 forces us all to think about.
Today, we're diving deep into Section 44 of the Bharatiya Sakshya Adhiniyam 2023. Now, this is a crucial section that deals with how an opinion about a relationship can actually become relevant evidence. It's a really important topic for anyone preparing for the judiciary and APO exams. So, let's get right into it.
So just imagine this for a second. A court is facing a critical question. How do you prove that two people are related, especially if there are no official documents? Is a marriage certificate the only way to prove a marriage, or is there another way? Well, Section 44 gives us a very practical and very essential answer to this exact problem. Okay, here's how we're going to break it all down today. First, we'll cover the absolute basics of Section 44. Then we'll deconstruct its key legal ingredients. After that, we'll explore how it's actually applied using important case laws, understand its context and limitations, and finally, we'll wrap it all up with some key revision points just for your exams.
All right, let's kick things off with our first section, the basics of Section 44, which is titled Opinion on Relationship When Relevant.
Think about it. In cases involving inheritance, succession, or other complicated family matters, a court often has to figure out the exact relationship between people. But, relationships, especially those from a long time ago, might not have perfect paperwork. Finding direct proof can be incredibly hard. And this is exactly where Section 44 becomes so important.
So this is the heart of the law. Let me put it in simple terms. When a court needs to figure out a relationship, the opinion of a person is considered relevant, but only if two conditions are met. First, that opinion has to be expressed through their conduct, their actions, their behavior. And second, that person must have special means of knowledge about it, which usually just means they're a family member or someone who knows the family really well.
So we have the basic idea. But what are the exact legal components that a court is looking for? To really understand Section 44 with total clarity, let's break down its key ingredients.
This section really rests on four essential pillars. First, there has to be a question of relationship in front of the court. Second, the evidence must be an opinion by conduct. It's not about what people say, it's about what they do. Third, the person whose conduct we're looking at must have special knowledge of the relationship. And fourth, and this is very important, there's a crucial limitation, which means this kind of evidence isn't enough proof for certain criminal offenses.
Let's see how this works with a practical example, one that comes straight from the act itself. Suppose the question is, are A and B married? The evidence that's presented is that their friends and family have always, over a long period of time, treated them as husband and wife.
Well, under Section 44, this collective conduct is considered relevant evidence of their marriage. See how that works?
So, that's the theory. But how has this principle been interpreted and applied in real courtrooms? Well, understanding the case law is absolutely key to mastering this section. So let's examine its application through some landmark judgments.
Here's another powerful example for you. If the question before the court is whether A is the legitimate son of B, the fact that all the family members have consistently treated A as B's son becomes a very, very relevant piece of evidence to establish that relationship.
And that brings us to a landmark judgment that every single law student needs to know. Bharatiya Prasad versus the Deputy Director of Consolidation. This case is absolutely essential for understanding the whole idea of presumption of marriage.
In this case, the Supreme Court laid down a vital principle. It said that if a man and a woman have lived together for a long time as husband and wife, the law will create a strong presumption that they are, in fact, married. This social recognition is at its core a form of opinion expressed by conduct, but on a much larger scale.
Another really significant case is Tulsa versus Durgatiya. This judgment helps us further clarify the evidentiary value of how a family treats one of its own members.
Here, the court held that the continuous and consistent treatment of a person as a member of the family is strong evidence of the underlying relationship. You see? This directly backs up the core philosophy of Section 44.
This entire principle is supported by a foundational legal maxim, pater est quem nutie demonstrant. It simply means the father is he whom the marriage indicates. The law presumes that a child born during a valid marriage is the biological child of the husband. And evidence of conduct under Section 44 is often used to first establish the marriage, which then triggers this very presumption. Okay, now that we've understood its application, it's time to put this section in its proper context. And more importantly, we need to understand its limitations, especially with the new criminal laws in place.
Now, this is a critical point for all you judiciary aspirants. This provision used to be Section 50 of the old Indian Evidence Act of 1872. Under the new Bharatiya Sakshya Adhiniyam 2023, it's now Section 44. The principle is exactly the same. There's been no substantive change, just a renumbering and an update of the references to the new criminal codes.
And now for the most critical limitation, which is found in the proviso to this section. An opinion on conduct is not enough by itself to prove a marriage in criminal cases for offenses like bigamy, which is under Section 84 of the Bharatiya Nyaya Sanhita, or adultery under Section 82. For these serious criminal charges, the law requires strict proof of marriage, things like a marriage certificate or testimony from the priest who performed the ceremony.
All right, let's bring it all together and consolidate everything we've learned from an exam point of view. These are the points you absolutely must remember for your judiciary and APO exams.
For your prelims, you can definitely expect a direct question on Section 44, or maybe even on its old number, Section 50 of the IEA. For the mains, be prepared for a problem-based question, maybe involving inheritance or legitimacy. Or you could be asked to write a short note on the concept of opinion on relationship as a relevant fact. Okay, for a super fast revision, just lock these 4 points into your memory. 1. The section is 44 of the BSA 2023. 2. The core concept is opinion on relationship, expressed by conduct. 3. The key limitation applies to sections 82 and 84 of the BNS. And 4. The landmark case is Bharatiya Prasad. Got it?
So, to wrap up, I'd like to leave you with a question to think about. When you consider its proviso, how do you think Section 44 manages to strike a balance between accepting practical, real-world evidence of relationships on one hand and guarding against its misuse in serious criminal cases on the other? Give that some thought. For more legal content focused on judiciary, APO, and other law exams, please stay connected with us here at Gunga Education.
Have you ever really thought about why an expert's opinion holds so much weight in a courtroom? Well, it's not just about what they say, but more importantly, it's about why they say it. Today, we're diving deep into Section 45 of the Bharatiya Sakshya Adhiniyam 2023. This section deals with the grounds of an opinion. And let me tell you, for your judiciary and APO exams, this section is absolutely critical. So let's get right into it. So, here's our game plan for today. We'll start with an introduction, then we'll deconstruct the core ingredients. After that, we'll see how it works in practice with some case laws, compare it to the old law, and finally wrap up with a sharp focus on what you need for your exams. All right, let's start at the very beginning. What is the fundamental idea, the core principle, behind Section 45? I want you to think of an expert's opinion as just the tip of an iceberg. It's what you see above the water. But the real strength, the real substance, is the massive foundation hidden underneath. Section 45 basically says that if a court is going to look at the tip of that iceberg, the opinion, then it absolutely must examine the foundation beneath it, the grounds. This is what ensures transparency and allows the court to really test the strength of that opinion. And you know, what's beautiful about this section is how simple and direct the language is. The Bare Act says, whenever the opinion of any living person is relevant, the grounds on which such opinion is based are also relevant. That's it. In simple terms, it just means if your opinion matters, then your reasons matter just as much. It's not complicated legal jargon, it's pure common sense. Okay, so now that we have the main principle down, let's start peeling back the layers. Let's break Section 45 down into its essential legal components to get a much deeper understanding. For Section 45 to even come into play, 3 essential conditions have to be satisfied. First, you need a relevant opinion, and it has to come from a living person. Second, there must be some grounds or a basis for that opinion. And third, and this is the key, those grounds themselves become relevant in court. So we're throwing around these terms like relevant opinion, living person, and grounds of opinion. But what do they really mean? Let's break it down. A relevant opinion isn't just any random thought. It has to be legally admissible under the Act. A living person could be anyone from a top forensic scientist to someone simply familiar with a particular person's handwriting. And the grounds of opinion? Well, that's the heart of the matter. It's the how and the why. It's the entire backstory to the conclusion. All right, now this is where the theory gets real. Let's move from the textbook to the courtroom and see how Section 45 actually functions in the real world through practical examples and landmark judgments. Let's imagine a really tense courtroom scene, maybe a poisoning case. A forensic expert gets on the stand and states, the victim was killed by a rare poison. Now, that sounds dramatic, but under Section 45, it's simply not enough. That expert now has to take the court on a journey through their lab work, explaining the complex chemical analysis, the specific tests they ran, and the exact data they got. That whole process, not just the final conclusion, becomes crucial evidence. And this isn't just a hypothetical. This very principle was powerfully established in the landmark case of State of HP versus Jai Lal. This case was a real game changer. The court made it crystal clear. An expert's opinion without solid reasoning is just, well, an opinion. It's the why and the how that elevates it from a mere suggestion to powerful, credible evidence. And the courts didn't stop there. This idea was further strengthened in Murari Lal versus the state of Madhya Pradesh. In this case, the court went a step further. It said that the value of an expert's opinion doesn't come from their qualifications or reputation, but depends entirely on the reasons that support it. So it's all about the logic, not just the expert's credentials. You know, this whole idea is captured perfectly in a classic legal maxim, judex est judex peritorum. It means the judge is the ultimate expert of experts. And what that tells us is that while the court listens carefully to specialists, at the end of the day, it's the judge who wears the final hat. The judge is the expert of experts who makes the final call. This makes sure that justice is never just delegated to a lab coat or a PhD. Okay, so I know a question that might be on your mind with all these new acts. Is Section 45 a brand new concept? Let's do a quick comparison with the old Indian Evidence Act to clear this up. The short answer is no, it's not new. As you can see, this exact provision was earlier Section 51 of the Indian Evidence Act of 1872. Under the new Bharatiya Sakshya Adhiniyam 2023, it's now Section 45. So here's the key takeaway for your exam, and it's simple. There's no substantive change to the law itself. It's only been renumbered. All right, let's get to the part we've all been waiting for. How is this actually going to show up on your exams? Let's zero in on the exam focus and do a quick revision to make sure this knowledge is locked in. For your prelims, you should expect a direct question. They'll likely ask you about the section number, Section 45 in the new act, or its old number, Section 51. But for your mains, that's where you can really demonstrate your understanding. You might get a problem-based question involving an expert witness, or they could ask for a short note on the relevance of the grounds of an opinion, so be ready for both. So, to wrap it all up, let's do a quick recap. Just remember these 3 things. 1, the section is 45 of the BSA. 2, The core concept is that the grounds of an opinion are crucial to test its validity. And 3, its exam importance is high for both prelims and mains. The next time you analyze a case with expert testimony, don't just stop at the conclusion. Always ask, what's the foundation? Because that's where you'll find the key to the truth. For more such legal deep dives, stay connected with Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.